Hi, Kristen. How are you?
Hello. Good. How are you?
No talk. Um, I was gonna say thank you everyone who's already here early. I started it early, a little bit earlier than normal. So I'm gonna have our wait for Danielle to pop on from our office, and she's gonna share my PowerPoint so I can read along with the notes. But we'll just take a couple minutes while people come in and start at noon. I'm on mute this whole time. So sorry, Amy, I saw, hi Tammy. I saw Amy. Yeah, I saw that you're in the participants. Let me see if I can. Okay, Amy, there we go. Okay. I think I fixed that. Tammy, do you want to join as a panelist as well? Hi, Amy. Sorry about that. All right, we'll get started in just 1 minute, everyone.
Let me get to where I need to go so I can get that presentation up.
Oh, yes. Thank you, Danielle. I really appreciate you
Oh,
sharing it for me.
absolutely.
It's sometimes I've figured out how to share it and be able to see my notes at the same time, but and it's like sharing your partial screen.
Hmm.
And I think it gets blurry on your end when it's like that. So Kristen, do you want Tammy to hop on as a panelist as well?
If she'd like to.
If she'd like to, I'll give you the option.
Yeah, give
I'll
her
give you
the
the
option.
option, Tammy, because I'm gonna, I'm gonna call on Kristen or for a little backup if need be. So I'll promote you just in case too. Think I've got everything though, Kristen, but just in case.
All right, Renee, can you see that?
Yes, I can see that. Can everyone else see it? Perfect. Okay, and I'm sorry, Tammy, I can't make you a panel. I don't know why I could make Amy a panelist, but no, now I can't make anybody else a panelist. So I'm sorry about that.
Okay, so Kristen and Amy, I'm going to be monitoring the PowerPoint presentation and I will be moving it when Renee tells me to. So if one of you guys could maybe monitor the Q&A or the chat, just because I don't think I'll be able to see it on my end.
Great. Thank you guys. So I guess that is a good time to get started. Obviously, we might have some people rolling in after the noon time, but that's okay. So welcome to our special education legal clinic. It is our first session of the 2025 season. I guess we're still technically in the 2024-2025 school year, but first of the 2025 year. So we thought the best way to kick that off would be to go back and do a year in review of the critical developments in the special education case law in 2024. Before we hop into that, I just want to go over, the general housekeeping, of course. If you want this webinar will be recorded right now, and let me double check. It is recording. So the webinar is recording and the recording will be available on our website, which is lawyerslegal clinic. Or if you search Special Education Legal Clinic Ohio, it'll come up on Google as well. So you can access the recording there afterwards, and you can sign up for our other workshop sessions as well. If you have any questions during the presentation, I'm happy to answer them. Both Danielle and I will not be able to see the screen just because we'll be controlling the presentation, but Amy and Kristen have volunteered to monitor the Q&A in case anyone has any questions. Feel free to, jump in, Kristen and Amy, and stop me at any time especially if it's something, about the case that we have questions about. And then our next presentation will be on, I should have pulled up my calendar before this, but we usually do it on the third Monday of every month. This week is on a Tuesday because of MLK Day yesterday, and next month it'll also be on a Tuesday because of President's Day. So that'll be on February 18th, will be our next session. And again, you can sign up at that lawyersforstudents.com/legal clinic. And I think the last thing I forgot is this legal clinic is a collaboration between Abdnour Weiker, Disability Rights Ohio, and the Ohio Coalition for the Education of Children with Disabilities, all represented here on our panel. So like I said, feel free to drop questions in the Q&A box and I'll answer them as we go along. But I've got, I was going to say, maybe I should be able to keep track of the time, so we'll be good. I'll be keeping track of time, but we've got a lot to cover today. So let's jump right in. Danielle, you can go to the next slide. So the first one we're going to talk about, and I already need a sip of water after all of that, and I'm sure I'm going to take a couple more as we go through this today. But the first one we're talking about is WA versus Clarksville Montgomery County School System. This decision came out on May 24th of last year, and it was out of a federal district court in Tennessee. This was an unofficially published decision that addressed various IDEA claims of the parents of a 12th grader with dyslexia. Perfect, Danielle, perfect timing. So this was about the student is, on a lot of these, you'll see that we don't know the student's name because a lot of times you'll see them as acronyms or possibly Jane or John Doe. Here, this is WA as our student. So his IEPs since moving into the district in 5th grade had identified his classification as SLD and focused and all of his specialized instruction was focused on fluency and written expression rather than basic reading and writing skills. So during the entire period, the entire period that the school addressed, from 5th grade all the way through grade 11, the students' grades were mixed, but largely good. He had been using some workarounds, some technology workarounds like AI and Grammarly for reading and writing, just to help him kind of get through everything. So the recognition of that underlying issue that he had was pretty slow. In grade 9, he had a comment from a special education teacher sent through email to the school psychologist saying, quote unquote, "This kid can't read." And in grade 11, one of his general education teachers had conveyed a similar concern to the student's mother, adding that, if they had done additional screening, there might be an underlying diagnosis of dyslexia. So during that grade 11 school year, the parents who are CA and EA, a lot of times when you protect the students' initials, they also protect. Sometimes, not always, they will protect the parents' initials as well, just for that continuous anonymity. So CA and EA are the parents, had requested 2 independent educational evaluations, which actually both provided diagnoses of autism and ADHD. And he was also, they found out he was in the 0.1, I can't, 0.1st percentile. So even lower than the first percentile, 0.110th of a percentile. I'm sorry, I can't think of how to word that, but a 0.1 percentile rank in, the battery of reading and writing tests that he had gotten done. And the second IEE had identified dyslexia and dysgraphia and had recommended some specialized instruction in those more basic reading skills and writing skills, in addition to fluency as well. So as a result of all of that, the parents had arranged for a private tutor in the Wilson Reading Program. The dyslexia specialist who provided that tutoring had attended the meeting for the grade 12 IEP and had recommended the continued use of her methodology through the Wilson program. However, when the 12th grade IEP came back, the district proposed, to continue to focus on the fluency in written expression and only added that autism qualification to the SLD classification. So it didn't really address those basic reading and writing skills that he was missing, as well as the fluency, and didn't really address those dyslexia needs. So at that time, the parents filed a due process hearing to challenge the appropriateness of the previous and the proposed IEP. And at the initial decision was that the hearing officer ruled in their favor. And he relied on Andrew F. to do that. Now, Andrew F., I think we might have noticed, and you'll see Andrew F. noted a few times throughout this presentation, because Andrew F. is a 2017 U.S. Supreme Court decision. The full title is Andrew F. v. Douglas County School District. And that was a case that was clarifying the standard for a free appropriate public education, the FAPE, under the IDEA, which is, I don't think I mentioned this, but that's the Individuals with Disabilities Education Act. And according to the Supreme Court there, the correct standard of FAPE was whether the school district had presented an IEP reasonably calculated, and this is a quote from that Kate from Andrew F. An IEP must be reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances. So that's really that standard that judges are looking at when deciding whether a school provided a FAPE was that IEP reasonably calculated to enable a child to make progress in light of their unique needs. In the initial decision, the due process officer found that yes, the IEPs were inappropriate and they were not reasonably calculated for the child to make progress. And he also he relied on this, but also included in his analysis the failure to provide dyslexia-specific interventions per the state's dyslexia law. And of course, again, just as another reminder, this is Tennessee, but Ohio does have some pretty similar dyslexia laws that have just been implemented within the past few years. So at that time, he awarded compensatory education, 888 hours of dyslexia tutoring by a trained specialist in that Wilson program. So both parties appealed at that point. The parents were seeking, at that point, it was, they wanted the dyslexia tutor to be provided by a private center. So that is why they appealed, because the judge's award hadn't been specific that it was a private provider. It still allowed the district to provide those services. And the district challenged the hearing officer's decision much more broadly. Of course, they wanted the finding that their IEPs were appropriate. So that led to this appeal. And Danielle, you can go to the next slide. So the district, since it was mainly their appeal, their first argument was that the hearing officer had erred by relying on state dyslexia law. And they were trying to claim that state dyslexia law wasn't specific to special education, so it couldn't be, tied to an IDEA claim, and that dyslexia law was just specific to general education. And the hearing officer rejected that argument for, to me, I thought it was a kind of silly argument. Of course, we've got dyslexia if it's a unique need of the child and they need services based on it. Of course, they need it for a FAPE. So the court had concluded that because the IDEA defines FAPE to incorporate state standards under its definition, without any special distinction between general education or special education, the state dyslexia law was a relevant consideration in connection with the parent's FAPE claim. And the district, so they declined and rejected that argument. So the district then argued that the hearing officer was unduly focused on whether the student had received dyslexia-specific interventions rather than passing grades. So they were saying, his grades were fine. They weren't, abnormally too low or outside of his gen ed peers. And so they thought the court was focusing on whether or not he had dyslexia-specific interventions rather than whether he making progress through his grades. The court rejected that argument and concluded that, the hearing officer's analysis was appropriately not specific to dyslexia, but that the hearing officer's analysis really was focused on the district's failure to address the student's individual needs under Andrew F. and failed to provide that specially designed instruction targeting the persisting needs that he had shown throughout several school years for those foundational skills in reading. And his grades just did not address that due to his technological workarounds, because he was using things like AI, Grammarly, all those fun stuff to help him. So that argument was rejected as well in favor of parents. The parents, as I noted, the parents also had an argument for, or a reason for appeal, and they were appealing a modification of the compensatory education award. So it would restrict the delivery to a private dyslexia center rather than through the public school district providing those compensatory education hours. Unfortunately, for the parents, the court rejected this argument. They found that the parents had failed to prove that the district was incapable of providing the ordered instruction with its own personnel or another outside option beyond the specific dyslexia center that the parents had chosen. However, the court did end up removing the requirement of a reading interventionist to make it more broad and make sure that there were more people able to serve the student under that compensatory award. So next slide, Danielle. So what are the implications of all of this and of the court, going through this and rejecting these arguments? So to relevance to Ohio, of course, this case was out of the Middle District of Tennessee, a federal court in there. Tennessee and Ohio are both in the Sixth Circuit are both within the Sixth Circuit Court of Appeals. So that Sixth Circuit covers Ohio, Michigan, Kentucky, and Tennessee. So while it was in the lower court and Middle District of Tennessee and focusing on Tennessee state law, it's not necessarily relevant or not necessarily binding in Ohio. I don't want to say it's not relevant. It's not necessarily binding, as in if you had this same case come into a federal court in Ohio, they wouldn't necessarily have to follow this decision, but they could look to this decision as guidance because it is within their circuit. And I also wanted to point this case out as well because I can absolutely see similar issues arising due to Ohio's new dyslexia law. But this ruling could support a parent's argument for those dyslexia-specific interventions to the student that's not making appropriate progress, even if they're getting, average grades in those future cases. This could be a supportive argument. However, it's unfortunately not too helpful for the parents in terms of getting the exact placement or exact services that you want in compensatory education hours. But that is, not a new finding that we're finding. A lot of times the, courts have wanted those public school districts to attempt first and really have to show that they're not able to provide those services. So really this overall, yes, this could, I could see a similar finding in Ohio. Again, it's not necessarily binding, but really this case just establishes that districts cannot, just dismiss the state dyslexia laws as applying only to general education. They have to be considered when developing those special education services for our students. It also reinforces that passing grades alone do not prove that a student is receiving a FAPE. Schools must, again, provide those specially designed instructions to meet individual needs, like WAs specifically needed those basic reading skills and interventions, and they had failed to have done that. But the negative side of this, but not really new information to us, so to say, is that it does confirm that parents have to demonstrate that a district is incapable of providing services before restricting the compensatory education to a private provider, which again, that's not new, but just a confirmation within our Sixth Circuit issues. Next slide, Danielle. So the next one we will get into is out of the Sixth Circuit Court of Appeals. Excuse me. This one came out on August 2nd, and it is JL versus the Williamson County, Tennessee Board of Education. So again, this case is out of Tennessee, but it's within the Sixth Circuit Court of Appeals, which Ohio falls in. So I'll get to it in the implications, but yes, this is relevant to Ohio. This case with JL concerns whether he was shown entitlement to a stay put injunction under the IDEA. That stay put provision mandates that during the pendency of any due process proceedings conducted under the IDEA, the child will remain or stay put in the then current educational placement until resolution of the proceedings. So that's what this one is all about, whether the child in this case was entitled to stay put in his then current educational placement. And really, actually, this case, as I get into it, is arguing over what the then current educational placement qualified as. So again, we don't know the student's name here. His name is JL to us. He's a 14-year-old from Williamson County, Tennessee. He had qualified under the IDEA for emotional disturbance, which had stemmed from diagnosis of disruptive mood disorder, ADHD, and he also had a severe history, or he had a history of severe behavioral challenges, which included aggression and elopements. So JL's 2019 IEP, these, in a lot of these cases you'll see are going back to 2019, 2020, those school years, because we have to go through the administrative processes before we even get to a federal court appeal. So that's why you'll see kind of these school years back a couple, like 4 or 5 years ago. But, starting at his 2019 IEP in 4th grade, he was placed in both the general and special education settings with behavioral supports. But due to escalating behavioral issues, which were verbal and physical outbursts, the district had proposed moving JL to a therapeutic classroom in October 2019. His parents, who also were, I don't want to say initialized, I guess that's not really the right word. His parents, SL and ML, had disagreed and which had prompted them to file the due process complaint. However, while that due process complaint was pending, JL's problem behaviors increased, and in the spring of 2020, so that was really, they filed in October 2019. It had only been a couple months. It takes, a couple months before the due process proceedings. So while this is all happening, his behaviors continued to increase, and the district wanted to remove him from the general education setting through an injunction, saying that he was a risk of bringing harm to himself or others. And that actually ended up, the parties ended up settling on this injunction in June of 2020, and had agreed to a homebound placement with 3 hours of weekly instruction. So in the fall of 2020, JL's parents enrolled him in a new private school, Robson Academy, and the district agreed to reimburse tuition costs. However, he still had behavioral issues and was dismissed in the spring of 2021 from that private school, and the parents opted for online homeschooling. So then we get to August 2021, where JL's parents wanted to re-enroll him in the public school. The district and the parents try to work together to find some sort of mutually agreeable IEP for JL to be able to come back to the school district and have the appropriate supports in his least restrictive environment. But the efforts had failed, unfortunately, and there was a second due process complaint filed, but the parents withdrew that in March of 2022. It doesn't really say why they had withdrawn it, just says they did, and ended up trying to enroll him in another private academy, but that was unsuccessful. And so it wasn't until December 2022 where they tried again to enroll him in public school. So really, he had been, just to kind of recap of where we're at, he had been in the gen ed special ed placement. It really, his behaviors were escalating. He was a safety risk to his other students. There was a due process complaint to try to move him to special education. But before that was resolved, there was a settlement agreement to place him in a home setting, and he ended up going to a private school, back to homeschooling, back to private school. Now he's back trying to get into public school. So by March 2023, unfortunately, this was unsuccessful again of trying to get an appropriate, of the team agreeing on what appropriate placement was for him for his IEP. And so in March 2023, JL's parents filed the third due process complaint, alleging that the district's IEP was denying JL with a FAPE in his least restrictive environment. So that initial decision there was in Tennessee, of course. The ALJ had ruled in favor of the district, and rejected JL's contention that he had stay put rights to placement within the general education setting of a Williamson County public school. They had wanted, because his last placement at the public school was that gen ed setting. Parents argued that while the third due process complaint was pending, that he should be entitled to stay put in that original general education setting he had started in the public school back in 2019. However, the ALJ dismissed it and found it illogical, and said that, his 2019 IEP placement at the elementary school could not serve a basis for stay put rights, where he's since graduated from elementary to middle school, and where his parents had unilaterally placed him in the private school immediately prior to re-enrolling him back into the public schools. So that decision was not in favor of the parents, so they ended up they appealed to federal court challenging the ALJ's order, and they also sought a temporary restraining, or not restraining, I don't think it's either a TRO, so temporary restraining or a restrictive order, and a preliminary injunction, which would enforce his right to stay put in his general education setting from the 2019 IEP. And the district court denied that. And so JL then appealed to the federal appellate court in the Sixth Circuit Court of Appeals. So next slide, Danielle. So the parents first argued that the district had violated procedural requirements under the IDEA by failing to develop an IEP that included parental input and adequately addressed JL's escalating needs. The court did acknowledge the disagreements, but ultimately held that the district's procedural efforts met the IDEA requirement. And the judge had noted that there were extensive IEP meetings and the district was willing to explore therapeutic placements, and that, those two factors demonstrated good faith and compliance. So that argument was rejected. The second argument the parents rose was that the district had failed to provide JL with a FAPE in his least restrictive environment by proposing placements that did not meet his individualized needs. Unfortunately, here the court affirmed the ALJ's determination that the district's proposed placements, including those therapeutic settings, were reasonably calculated to provide educational benefits tailored to JL's behavioral and academic needs, again citing Andrew F. that decision that the IEPs were reasonably calculated to ensure his progress. The judge in this decision emphasized that these placements were appropriate given JL's history of significant behavioral issues that disrupted the general education environment, and also emphasized again that the IDEA does not require the optimal placement, but one that is reasonably calculated to enable the progress appropriate to the child's circumstances. So that one again was rejected, unfortunately. The parents' third argument was that under IDEA's stay put provision, JL still had a right to remain in his last agreed upon placement, which was the general education at Bethesda Elementary School, while the due process proceedings were pending. Unfortunately, the court rejected this claim as well, finding that the parents' unilateral decisions to move JL to private schools and then homeschooled him constituted a waiver of those stay put protections, and they did use the word waiver. They noted that the 2019 IEP from the elementary school was no longer relevant due to JL's progression to middle school and the absence of an agreed upon placement after several intervening changes, which was also that homeschooling, those private schools, the homeschools and private schooling that they had unilaterally placed him in. So unfortunately, that one was rejected as well. And their last argument was the temporary restraining order and the preliminary injunction to enforce his stay put rights, arguing that he had to return to the general education classroom pending the resolution of disputes. And for the same reason, that argument was rejected, reasoning that the parents failed to demonstrate a likelihood of success on the merits or irreparable harm, which are the standards for a court approving a TRO and preliminary injunction. You have to show, the plaintiff has to show, or petitioner, whatever they're labeled as, has to show that there's a likelihood of success on the merits that would reasonably a likelihood of success on the merits that would reasonably be related to a TRO or a preliminary injunction, and that there would be irreparable harm if the court didn't approve of that TRO or the preliminary injunction. And unfortunately, the parents were not able to show that, mostly because the court had rejected all of their arguments. They also had highlighted that returning JL to a general education setting would be contrary to his documented needs and to prior agreements. So implications for that on the next slide, Danielle. Unfortunately, I was going to say, so I tried to stick really as positive as I could with these decisions, but of course, we're going to have a couple negative decisions on the parent side of things. So we just have to get through them and talk about them and how they're going to implicate things for the future. And this is one of those that just is not necessarily in favor of the parent. And this one is binding in Ohio. It's from the Sixth Circuit Court of Appeals. If you have a similar case coming in Ohio, of course, if there were any state laws that they talked about, it would be relevant to Ohio. But with regard to the IDEA claims, this is going to be binding in an Ohio court as well. So really here, the court reiterated that Andrew F. standard, and we're really looking at whether that IEP was reasonably calculated to enable a child to make progress, appropriate in light of the child's circumstances, even if that placement is not the most preferred placement by the parents. And that kind of is also coming from that decision in the last case we just talked about, where, even if it's not necessarily the parents' preferential, as long as it's reasonably appropriate, then, a judge is going to uphold it. The case also, again, it underscores that difficulty of balancing a child's right to be educated in the least restrictive environment, that gen ed classroom, and balancing that with the need for a restrictive placement to address like severe behavioral challenges. The ruling also clarified that the IDA stay put provision applies only when there is an agreed upon placement between the parties. So unilateral actions by parents, like enrolling a child in private school or homeschooling, may undermine those protections and may have them end up waiving those protections. So a school district is not obligated to maintain a student's previous IEP placement if that student has been withdrawn from the district for an extended period of time. Again, here it was about 4 years, and has undergone multiple unilateral placements by the parents. We talked about it, the court is saying that is a waiver of the right to stay put. This also emphasizes, the case also emphasizes that parental participation in those IEP meetings, but the court also underscored again that just parental disagreement alone does not automatically invalidate district proposed placements, especially if there's evidence that supports their appropriateness. And then finally, one of the overall implications of this case that I kind of mentioned, or that I haven't mentioned yet, but that we see a lot in these cases, are that courts will defer to districts a lot of the times, especially when the evidence that they have shows that the proposed placements are, within that Andrew F. standard, that reasonably calculated to provide an educational benefit, even if it's over parent objections. So that unfortunately was not a great decision for parents, but it's really just important for parents to know that, there has to be that agreed upon placement before enforcing stay put. And that, if you do end up unilaterally removing your child and bringing them back to the public school after some time, that they don't have rights to stay put in that original placement, that the district can propose a new placement that's in line with their needs. So Danielle, the next one, which is a better one.
I was going to give you a time check. We have about 30 minutes.
Okay. I'm going to talk really fast. I think I can do it. So this was a July 29th decision, AP versus McKnight, out of a federal district court in Maryland. And this addressed tuition reimbursement for a residential placement. I skipped over a slide. So this is talking about the child here is actually SP, the parent was AP. The child SP is a 7th grader with autism. The IEP, his IEP had provided for placement in a general education at the neighborhood a general education classroom at the neighborhood middle school, along with separate resource room services for 50 minutes a day. And it had been like that for the previous 2 years as well. However, during 7th grade, his aggressive behaviors escalated, which led to some increased monitoring during unstructured time and 3 short-term suspensions between November and March. His grades would, he was mostly in advanced classes, and his grades were A's and B's. They dropped temporarily in the 3rd quarter due to the assignments missed from those suspensions, but then returned to that A to B level at the end of the school year due to the makeup work. They had a March IEP meeting for the upcoming year, and the parents had requested placement at the district's autism program, which was at another middle school in the district. So still within the district, just not his neighborhood home school for middle school. However, due to his academic progress, and the school's belief that his problems were it was this way, were more behavioral rather than academic. The rest of the IEP team had recommended the home middle schools program, which focused more on social emotional skills. However, this team had disagreed, and there was at that March IEP meeting. So during the attempts in the next few days, while they were scheduling a follow-up meeting to finalize the placement decision of where he was going to be, the student had a serious behavioral incident at home, and the parents decided to place him at an out-of-state wilderness therapy program to avoid physical harm. And when he was discharged in May, his wilderness program therapist had recommended a placement in a residential treatment program. His parents ended up placing him, because of his escalating behavior, in a short-term program in a local hospital, and he was diagnosed with a disruptive mood regulation disorder. And then they placed him at a residential treatment center in Utah. Again, this is out of Maryland, but they placed him at a residential treatment center out in Utah, which included a specialized school, and the parents requested reimbursement for this placement. The team again met and had given him a primary classification of the emotional disability. The IEP team ultimately proposed a self-contained program at a regional day school, so somewhere local, with an interim placement however, there was a delay in being able to get him into that residence. So they were going to give him an interim placement at the home middle school while waiting to be able to get into that regional public day school for the self-contained program as they proposed. However, he was not admitted to that proposed day school program because he did not participate in an admissions interview, to no fault of the parents' own. They didn't know. But the school didn't communicate that reason to the parents. And the parents ended up filing a due process hearing, and the administrative law judge had decided in favor of the district. And so the parents appealed to federal court. And the next slide, Danielle. So the parents had argued that the district's proposed placement was not appropriate based on Andrew F. in combination with other Fourth Circuit case law. We're in the Sixth Circuit, like I said, this is Fourth Circuit over there, concerning those definitive proposed placements. And the court ended up agreeing with the parents and found that the proposed interim placement at the home middle school contradicted the district's determination that its own programs weren't reasonably calculated to address the child's severe behavioral issues. They had, agreed that he needed to be in this day program at a regional facility, but then said, your interim services can be at the middle school where you've been. And the court was saying that was contradictory. And they had found that the parents had engaged in that day school's admissions process in good faith. Again, the interviews were to no fault of their own, and they had in good faith, the parents had made their attempts. So the court accepted their argument, and the district attempted to counter argue and say that their unilateral placement that the parents had made lacked sufficient academic rigor and supports, and was too focused, on therapeutic mental health measures. The court here disagreed with the district's counter argument, which was in the parents' favor, and concluded that the school portion of the residential program was meeting that reasonably calculated standard, even if it wasn't optimal. So again, this was in favor of the parents, and that the implications here, of course, relevance to Ohio. There's a lot of variability in how courts interpret Andrew F. Of course, this isn't in the Maryland, Ohio doesn't have to use this case as binding, but especially in regard to behavioral and residential placements. But I still felt this important to show, unilateral placements based on unilateral placements based on a student's behavior, even if his academics are okay at A's and B's, is still appropriate and still can be reimbursed by the school district. So again, the decision just overall emphasizes again that Andrew F. standard. They have to be reasonably calculated to enable appropriate progress, including those behavioral and emotional challenges. And that a placement, if the placement fails to meet, identified behavioral needs, it's not going to satisfy the Andrew F. standard, even if the academic goals are met. And the court's acceptance of, a unilateral residential placement as meeting the reasonably calculated standard, even though it lacked that optimal, academic rigor that the district had wanted, it highlights the importance of addressing, the child's behavioral and emotional needs holistically. It also showed, it also shows that proposing interim placements that, of course, contradict prior determinations about a child's needs will undermine a district's credibility, and that, districts must ensure that continuity and alignment in proposed placements if they want to avoid those, legal vulnerabilities. Of course, and we also saw in this case, deference to parental good faith, which is important to consider as well. And that courts can consider, similar to, courts considering district good faith, similar to, oh yeah, I was still on the implications, sorry. Similar to, the court saying that, as long as the district's acting in good faith and kind of attending these meetings and doing whatever, they're going to defer to the district. While here, they were considering their engagement in the placement process as evidence of good faith. But again, this holding of the case relied a lot on previous Fourth Circuit decisions on what is considered a FAPE, which highlights just how the interpretation of Andrew F. standard may vary among jurisdictions. So we'd hope to see a trend this way in Ohio as well for similar cases, but it's not necessarily binding right now in Ohio. Okay, next one, Danielle. Okay, I'm looking at my time. I was gonna say the next ones are pretty short.
Yeah, I'm sorry. I clicked my screen just to click it. I clicked the next slide. So I'm sorry.
Oh yeah, no, that's okay. Next one was way earlier, about a year ago, January 31st, 2024, also out of District of Maryland. This was Lee versus Board of Education, and this was various IDA claims of a student who had attendance problems. So you can go next slide on this one too. So we have here there were various IDA claims of the parent of a seventh grader. So this is student CL-W was his initials, C, I'll just say for his first name. He had an SLD classification, and he had also had attendance problems that dated back to preschool and included, the total of absences in grade 5. He had 36 absences in 6th grade, 29 absences in 7th grade. He had up to 45. His mother was Lashik Lee, had reported to the IEP team that, his absenteeism was due to anxiety attacks, but the school personnel did not observe any particular anxiety in the classroom or in their evaluations. And his parent, and Lashik had also reported that she had arranged for wraparound mental health services due to defiant and disruptive behavior at home, and that he had a diagnosis of other conduct disorder. The school personnel reported progress in academic areas of his IEP, including reading, math, and speech, and had attributed any limited progress would be due to his absenteeism, and really noted that the only behavioral problem that he had at school was due to a lack of classroom participation and work completion. So the parent had requested various IEEs. The district only agreed to fund one of them, but did not file for a hearing for the disagreement for the other one. Instead, midway through that grade 7, the parents had filed for a due process hearing, or the parent, Lashik Lee, had filed. She claimed denial of FAPE in grades 5 through 7, which also included some distance learning due to the COVID-19 pandemic, and she sought comp ed. The hearing officer at the initial decision ruled that there was no denial, that Lashik did not prove a denial of FAPE for the 3 years at issue, so she filed an appeal in the District of Maryland Court, and you can go to the next slide. So the parent first argued that the district had violated the IDEA by shifting her this was the first two are really COVID related arguments. She had first argued that the district had violated the IDEA by shifting to virtual instruction without an IEP meeting. And the court rejected this argument and said that it was not a placement change. And even if it was a procedural violation, the parent had failed to prove any requisite resulting harm in her lack of participation or in the child's progress. So she tried another argument and claimed that the district failed to fully implement the child's IEP during that period of virtual instructions. And there was the judge cited mixed rulings and other decisions and interpreted federal guidance. And he interpreted the facts of the case in a really district deferential way and just concluded overall that the parents had failed to prove a material denial of the free appropriate public education, the FAPE. So then the parent turned to the issue of, the IEP's not addressing his attendance issues and his absenteeism. So her claim was that, the IEPs were substantially deficient or substantively deficient because they failed to include a functional behavior assessment to address the child's attendance issues. And the court actually agreed that the IEPs were not sufficient enough to provide for the child's attendance issue, but rejected the parent's argument because they found that the lack of the FBA, although a procedural violation, the parent had failed to prove the requisite harm that had come out from the failure of the school to do an FBA. The parent also argued that, the district was required to fund the requested IEEs or to file for due process to defend its own evaluations. And the court again agreed and said, yes, that was a procedural violation, but sorry, Ms. Lee, but you failed to show that the procedural violation was connected to any lack of progress or resulted in any harm. And so lastly, again, the parent also tried to claim her last argument was that the district failed to consider her IEEs, and the failure to consider the IEEs was in violation of the IDEA. The court again concluded that yes, this happened and this was a failure. It was a procedural violation, but the parent didn't prove any resulting substantive loss of faith. So the implications of this, again, not a great decision in our favor. I said they weren't always going to be sunshine and roses. The implication of this case, it really highlights the challenges that parents face when making claims based on mainly procedural violations under the IDEA. Courts that prioritize the student's actual education loss over procedural shortcomings will often set a high bar for those parents to succeed. And in this instance, the court seemed to place a significant weight on the parent's burden of proof and showed strong deference to the school authorities regarding decisions about the student's educational needs. So it just wasn't the greatest decision. Of course, again, this is the same district court that we just spoke about. They came out with a good decision and then not so good decision. So again, this one's not binding in Ohio, but this case really struck out to me because we see all the time kids coming in with absenteeism as an issue. And we want to see that addressed on their IEPs. But here this court is saying, you really have, and this is true, you have to show that substantive harm of a lack of FAPE or, lack of progress associated with those procedural violations in order to have a claim. And again, they really were focusing on federal guidance for that virtual learning as a placement. And again, like I'm saying, these procedural violations, they might not result in a ruling in a favor against districts unless parents can demonstrate that harm or a loss of educational benefit. So the next one is Hempfield School District versus SC. You can go to the next one. This one is, and I am keeping an eye on the time. We have 2 more cases, so that's perfect. Okay, so we have Hempfield School District versus SC. And this is a case about, and this was January 31st of this year, maybe January 1st. I think I typed it in wrong. The case was about ongoing staff shortage issues in special education. So thank you, Danielle. I will this one has a bit more facts, but I'll kind of summarize them a little bit more quickly. In kindergarten, the student, who in this case was SC, he's got classifications of autism and speech language impairment. And he had an IEP that provided him with 85% of the time in an autism specific classroom and 15% in the general education classroom. He's mostly nonverbal, easily distracted, and very focused on self-stimming behaviors. He had a difficult transition to a full school day, so his support classroom also consisted of 8 students who were mostly nonverbal, behaviorally problematic, not toilet trained, and with a special education teacher and 4 aides that were all trained in verbal behavior methodology. In that October 2020, during that school year, the special ed teacher took a maternity leave, and an autism support coach, who was rotating among the district's 6 different autism support classrooms, notified the parents that she would be assuming the teacher's role until the district could find a long-term substitute. So for the rest of the school year, the coach was providing instruction in the classroom for 2 to 3 days a week, supplemented by a bunch of substitutes coming in and out that didn't have any training in the verbal behavior method. And because of the child's complex needs, because of SC's complex needs, the substitutes rarely worked with him, and the aides were confused on how to implement his IEP when the coach wasn't there. And due to those staffing issues, the students were not, I think I said 85 in gen ed, or 85 in autism classroom, 15 in gen ed kind of extracurriculars and things. But because of those staffing issues, the kids never, like, very rarely left the classroom for lunch and for recess and for specials. When the special ed teacher was supposed to come back in February 2021, she ended up resigning, and it wasn't until the end of the school year that the district found and hired a replacement. When he was in first grade, the new teacher started with 1 less aide, and the teacher was expressing staffing concerns to the special education director, and saying they didn't have enough support in that classroom. And because the situation was unresolved, 2 of the aides left that classroom. So when the parents learned about all these shortages, they met with the SPED director, and the SPED director offered some compensatory sessions for that 14 delay before a new speech therapist specifically had started, but informed them that she had not received any applications for the aide vacancies that they were trying to fill. So the parents were trying to find a suitable private placement within, commuting range for them. And they were able to find him enrollment in a nearby another school district's autism program on a tuition basis. And so after informing after that, they did inform the special education director that they would want to come back after, after there's a resolution of the staff shortage, when they get all the staff hired. Unfortunately, the placement but they were going to actually end up staying at that private school or the other public school because they liked it, but unfortunately there wasn't any more space due to just their own staffing issues. So they were not allowed to, pay that tuition anymore. So the parents re-enrolled in the school district and filed a due process hearing, and we're seeking compensatory education for that kindergarten and that part of first grade where there were staffing issues, and then as well as reimbursement for the second part of first grade for that tuition that they paid. The hearing officer ruled that he did have a FAPE in kindergarten, but not during grade 1, and awarded 65 hours of comp ed for the first few months and reimbursement for the remaining period, and both sides appealed to federal court. And you can go to the next slide, Danielle. The parents argued, for kindergarten and first grade, their claim was based on failure to implement the IEP rather than those procedural or substantive dimensions of FAPE and that Andrew F. Standard. And so and this is the third circuit here, or it was within the Eastern District of Pennsylvania. They did accept this argument and disagreed with the hearing officer's, reliance on the assessment of the child's progress, and the school and had concluded that the school district did fail to implement substantial and significant portions of the IEP during both the child's kindergarten and first grade year. And so that was a good outcome. The district argued that a unilateral placement at another school district is not available for reimbursement, and just said it really, and kind of made the argument that it's only private schools, which is an interesting argument. The court rejected that and said, the reimbursement analysis is whether the unilateral placement is appropriate, and it's not limited to private versus public schools. And then on the compensatory education side, both sides agreed that the hearing officer's award was arbitrary. And so the court did remand that back to the hearing officer to more carefully calculate that compensatory education award and make sure that it's counted for both kindergarten and that part of first grade. So really quickly, implications on this one. Really, again, this is not in Ohio, but even in Ohio, districts cannot use special education staffing shortages as an excuse for failing to fulfill their FAPE obligations. Again, this one's not going to be binding, but I just took a quick quote from this is literally the first paragraph of the decision. I'm just going to read it, but it says, teaching young children on the autism spectrum is a special calling. Finding qualified teachers and professionals to teach kindergarten and first grade students on the autism spectrum during a worldwide pandemic presented greater challenges. Teachers leave and the schools must still teach. The schools must be mindful. Congress mandates that states accepting federal education funds provide a free, appropriate public education to students in their district and must hire staff to do so. And the school district must reimburse parents forced to pay tuition at another school if the school district cannot provide the required education. Of course, again, this was out of Pennsylvania, so not necessarily binding in Ohio, but I mean, that is pretty standard and going to be, I think we would see this going across Ohio courts, similarly emphasizing that need for the districts to meet those provisions of the IEP, regardless of the student's progress. So, okay, I have one more case. I think I can do it in these next couple minutes, especially because this one is a little bit shorter. So, September 3rd, this is DC Circuit Court of Appeals, again, not Ohio. Pierre Noel versus Bridges Public Charter School. Danielle, you can go to the facts. This was about KN, who is a nonverbal child with multiple disabilities. He was medically fragile and required one-on-one nursing services to assist with his needs. And his IEP had included transportation on a school bus with a dedicated nurse to monitor his medical equipment. However, his mother, I think it's pronounced Margda, Margda, Margda Pierre Noel had requested that, and the school district declined, for a nurse to move him between the front door of his wheelchair inaccessible second floor apartment and the school bus. So she essentially wanted an aide to go into their apartment building, go up to the second floor, meet at the apartment door, and bring him down to the bus. And the school declined this. And this had only become an issue at that point because parents had carried him down before and were just carrying him down, but then he was getting too heavy for them to do it safely. School declined, parents filed for due process hearing, and the hearing officer at that level had ruled that the transportation obligation only extends to the outer door of the building, not into the apartment building, and so that the school was meeting their obligations. The parents appealed this, and the federal district court had affirmed this part of the hearing officer's decision. The court, concluded that moving the child to and from his apartment door was not transportation and was not a supportive service under the IDEA. So the parents filed an appeal with the DC Circuit Court of Appeals. And Danielle, you can go to the analysis. Their first argument was based on the related services meaning and what the meaning of transportation was. So the districts, I kind of go backwards a little here with the counter arguments and arguments, but the district's counter argument was, transportation is focused on vehicle and it's really about getting the child on and off the bus. And the court said, nope, we're relying on dictionary definitions that, don't limit transportation to a vehicle. And the IDA statutory definition of related services extends to anything that is required to assist a child to benefit from special education, as well as the legislation's obligations, all of that to say that no, it's not just vehicle centric. And so the district again tried to say, okay, if it's not vehicle centric, the transportation is limited per the IDEA regulations to and from schools and in and around buildings. And the district court actually rejected this and reasoned that the regulations cannot narrow the scope of the statute And in any event, both quoted parts are naturally not limited to vehicles and to the extent needed, immediately adjacent curbside assistance. So I was actually in favor of the parents, and the parents had argued, the disputed movement is a supportive service under the IDEA, which essentially was declined to address this argument, because they found it unnecessary in light of its ruling in favor of the parent for its transportation service argument. So they did find that, transferring the student from the second floor door of their apartment building, to the bus from that level and going into the building like that was considered transportation. And so they didn't look at the related services argument because they already said it was qualifying as transportation. They also had, said it was a related service, and they declined to address this as well. They left it for another day to specifically say what a child or what a student would need to prove, the requisite need for this specific related service, which would be going in, specifically going into the apartment and coming out. And they had, left this for another day because the district had conceded that, yes, if this is considered a related service, that yes, this child, based on his needs, does need that related service, that transportation service. So implications, so implications, again, that's expanding that definition of transportation beyond just vehicle related services, and reinforces that transportation can extend beyond the bus and into a student's home environment, especially when necessary for the child to benefit from special education. Again, this was out of DC, so not necessarily binding, but just something that we could also see, a similar interpretation in Ohio. It also indicates that, districts can, they also had highlighted that the districts can meet those transportation obligations using alternatives, like they didn't have to just physically carry them, they could use specialized lifts or ramps. And so Ohio schools must consider that, transportation obligations similarly could be interpreted broadly under the IDEA, including support for moving children to and from the school bus, especially when the medical or physical needs are involved. And so next slide, which is the last one, and I did it at 12:59. Really what's in store for 2025. I have to say this really fast. There's a lot of information, but Disability Rights Ohio does have a pending case right now, related to the Warren County Educational Service Center and some of their lack of providing a FAPE to the students. There's a class action filed against them, and I can't get into too many details because we're short on time, but I know there is a lot of articles out there about it, and maybe even on DRO's website. I don't know if you have anything on your website about it, but we've got a pending decision, a motion. There's a pending motion to dismiss right now, so we'll hear back from that in 2025, and we'll be able to send you guys an update with hopefully a positive decision out of that, and for those kids to move forward and get what they need out of FAPE. But there's nothing really on the Supreme Court's docket right now that's special education related, and I couldn't find anything within the Sixth Circuit other than really that Warren County Warren, I keep saying, yes, it is Warren County, right? Yes, thank you. That Warren County Educational Service Center issue. So, I've run out of time, unfortunately, so I can't get too into it, but that's okay because it's still pending. The case is still going on, and that's what's in store for 2025. It's hopefully a good decision for our students out in Warren County. So we'll be looking forward to hearing some positive updates from DRO for that. I didn't really leave any time for questions, and I'm so sorry about that. I just wanted to give you guys all the knowledge and information, everything that's going on. Of course, if you guys do have any questions or anything follow up and want to send me an email, my email is Renee, RENEE @awlawohio.com. Let me put it in the chat real quick so everyone can see it. So if you have any follow-up questions, I don't think I had any questions in the Q&A box, so I must have done a really good job of explaining. So thank you guys for, and I'm just leaving, if anyone does have a last minute question, I don't see anything popping up, but thank you guys. I know I went over a little bit of your time, but I appreciate everything. And we will see you next month. I don't know off the top of my head what our let me see if I can check real quick what next month is so you guys can sign up. It is aid, support, and related services, and all about the legal requirements and practical solutions related to gaining those aid, support, and related services. And that'll be by Abdnour Weiker next month, Tuesday, February 18th. So thank you, everyone. And yep, just double checking one more time. No questions. Hope everyone has a great afternoon.